Hello everyone, welcome to USTM podcast. I am Niharika Saikia, Assistant Professor of University School of Law and Research, USTM. Today we are gathered here to discuss about the new 3 criminal laws, and one of the laws is Bharatiya Nyaya Sanhita (BNS), which came into force from this month, that is 1st of July 2024. And for discussing these 3 new laws, we have invited a very special and eminent guest, Professor Subhram Rajkhowa sir, who have experience in this legal field more than 40 years. So I would like to invite Professor Rajkhowa sir to our studio to enlighten us about Bharatiya Nyaya Sanhita, that is BNS. Hello sir, welcome to our studio.
Thank you.
So kindly enlighten us about the Bharatiya Nyaya Sanhita Act, which is a new criminal act as we know. So kindly enlighten us, what's the relevance of this act?
Thank you. Today, we are here to discuss about the new criminal laws that have come into force from the 1st of July 2024. To give a background, the Indian Penal Code, the Code of Criminal Procedure, and the Indian Evidence Act has been repealed and replaced by the Bharatiya Nyaya Sanhita, the Bharatiya Nagarik Suraksha Sanhita, and the Bharatiya Saksha Abhidhan, that is Ovidiyam, that is the Indian Evidence Act. It was in the year 2019 that the Honorable Prime Minister made a statement that the laws, the criminal laws, the major criminal laws that are there in the country are of British vintage, and therefore these needs to be addressed. And accordingly, a committee was formed. It was notified on the 4th of May 2020 and nomenclatured the Committee for Reforms in Criminal Law. This particular committee was notified by the Home Ministry under the chairmanship of Professor Ranbir Singh, the Vice Chancellor of National Law University, Delhi. Other members included Professor G.S. Bajpai, Professor Balraj Chauhan, Ram Jethmalani, and P. Thareja. Subsequently, Praveen Sinha and Dr. Padmini Singh were also included as members of the committee. And this particular committee, after initial discussions, laid down a procedure to be followed. And since at that point of time the country was suffering from the COVID pandemic, they decided to seek online public consultations extending for a period of 3 months from 26th of June 2020 till September 2020. And in the course of the discussions of representations, then and subsequently, consultations took place with 18 state governments, 6 union territories, the Supreme Court, High Courts, advocates, judicial academies, law universities, followed by MPs and MLAs. In fact, 142 MLAs and 142 MPs and 272 MLAs provided their feedback and suggestions on the proposed law. And so far, this law was concerned, that was discussed and deliberated, and at a certain point of time, it was placed before the Ministry of Home Affairs. The recommendations were submitted, and based on the recommendations, a first draft of the bills were placed before Parliament on the 11th of August 2023. After initial discussions, it was sent to the Joint Standing Committee of Parliament and subsequently laid on the floor of the House on the 11th of December 2023. And it was on the 20th and 21st of December respectively that the Lok Sabha and the Rajya Sabha passed these laws, and it received the President on the 25th of December 2023. Now, why this repeal was necessitated? It was because we felt that the law of British vintage was colonial in nature, and therefore something had to be done to bring it in consonance with present times, making it justice-oriented rather than penal-oriented, that is, rather than giving more emphasis on punishment, but provide for justice. Significant changes in the legal landscape were introduced. It was revamped of seminal importance, and basic idea was to decolonize criminal laws of the British era and provide for an Indian identity that is to be justice-oriented and citizen-centric. Some of the important changes included the sedition law. There was a lot of criticism about the British old sedition laws. The matter was pending before the Supreme Court, and Section 124A was removed. And this particular act, that is the BNS in short, it comprises of 20 chapters and 358 articles against the earlier provision of 23 chapters in 511 sections. It deletes certain important sections like that of Section 377, 309. Then it adds new offenses as, for example, 48, Section 69, Section 95, Section 152, Section 103, Section 106, 304, 324, 341, and 358. Now, simply stating about the sections, it doesn't mean much. But then, thing is, a lot of changes were introduced and new provisions were added, providing for offender responsibility as well as reintegration or repatriation of the victims. The purpose was to provide for a responsive law in current times, and thereafter aim was to break the shackles of the past. And one of the important aspects was introduction of the Indian philosophy. So it has to be attuned to the Indian philosophy, that is justice and dharma. And therefore, what we have is that there are different categories of offenses under this particular law. Earlier there were 5 important categories, and a new category was added. And this important category that has been added relates to punishment with regard to petty offences. The committee felt, as well as the Honourable Parliament felt, that petty offenders were crowding the jails and it did not serve much purpose. For those offenders who committed petty crimes for the first time, so it has been proposed that they will have to serve some community service, community sentencing sort of, that they have to serve the community for a brief period of time instead of being sent to jails. So here, some salient features are very much in evidence. This law is gender neutral. Provisions are made for adultery. So there are some salient features which have been identified in the present Act. So it is a gender neutral law. It provides for stringent offences against women and children, deletes sedition as an offence, recognizes for the first time transgenders in the definition of gender. It recognizes terrorism as an offence and includes separatism and armed rebellion against the government, challenging the sovereignty of the country. It introduces a new offence in the shape of organized crime. Gang rape has been visited with up to 20 years of imprisonment. It involves a minor, and in that case, one can be awarded death penalty. Subversive activities are provided for under Section 152, and as I said earlier, sedition has been removed, but then that rasdro has been replaced by treason, that is desdro. So if someone is found guilty of treason, then necessary punishments would follow. In addition, as I said, in addition to death penalty, imprisonment for life that is simple imprisonment or rigorous imprisonment, forfeiture of property and fine under section 4F of the present law. A sixth form of punishment has been added, that is of community service. The new provisions include trial for abetment by persons from abroad. Earlier, if a person absconded or he was abroad, then the trial could not take place. Now that has been provided. In absentia, trial may commence against a person who has abetted a crime. And similarly, cybercrime has been added as an offense. Financial fraud too is being included. And here one important or significant aspect is that under section 69, it has been provided that if one enters into sexual intercourse on the false promise of marriage, in such a situation, that particular person would be liable to imprisonment which may extend to 10 years and fine. Hate crime has been provided for with murder. Hate crime leading to murder is provided with life imprisonment extendable to death. Similarly, under section 195(2), 1 year imprisonment with fine or both has been provided for in respect of threatening a public servant to commit suicide. That is, if someone says that if something is done or not done, then the person will commit suicide. In such a situation, that particular person would be deemed to have threatened the public servant. The most important provision is that of section 152. In lieu of sedation, it has been provided association, armed rebellion, subversive activities would lead to a sentence up to 7 years with fine. A new provision, another provision that has been added is that of section 304, that is snatching to commit theft. This was earlier not there, but now it has been provided if someone intends to, if snatches some property, maybe movable property, in that case, say a chain or something else, then depending on the nature of the offense, one may be liable to 3 years imprisonment and fine. But then counterfeiting of seals, place or instrument again has been provided with 7 years imprisonment with fine. So what we see is that several important provisions have been added, and one aspect that has raised a lot of controversy is that of death by rash and negligent act by a medical practitioner. So if a medical practitioner who is so recognized by the Commission, National Medical Commission, in such a situation, if such a person's negligence leads to death of a patient, then he or she would be liable to imprisonment 2 years with fine, and this has caused some amount of consternation amongst the medical professionals. Likewise, section 106 subsection 2 provides for 10 years of imprisonment in case of hit and run cases resulting in death. So here it has been provided that if a person, if a commercial vehicle or any other vehicle meets with an accident and the person or the driver flees the place of incident, he is supposed to report the incident, but if he flees, then he would be liable to 10 years of imprisonment. Community service has been provided for first-time offenders. Similarly, mob lynching, which has been in practice or a disturbing trend over the years, has been recognized as a new offense with severe punishments. Organized crimes, organized petty crimes, terrorist act, sedation, as I said, has been taken away with. But then identity theft of intangible assets, data, credit card skimming, etc., which are considered under this particular act to be an offense. So what has been deleted what has been done away with is Section 377. This has a background. In Navtej Singh's case in 2017, the Supreme Court decriminalized Section 377 with regard to consensual sexual relationship, and therefore this has been deleted. Again, Section 309, that is attempt to commit suicide. If someone attempts to commit suicide and fails in the act, earlier the provision was that he or she would be liable to punishment, but now that has been done away with. And similarly, adultery has been eliminated. There was a case in the Supreme Court, which judgment was delivered in the year 2019, which stated that adultery is considered to be archaic, arbitrary, and paternalistic, and therefore adultery has been deleted from the statute. So these are some of the salient features or some of the significant changes which have been introduced, and we believe that in course of time, once these are taken up in the court, the actual impact or effectiveness would be known. I mentioned about Section 358. This is an important section because when an act is repealed, it is considered to be gone. But here it says that under Section 358, it says that those offences which were pending, those cases which were pending, those FIRs which were registered prior to 30th of June or till the midnight of 30th of June would continue to be governed by the old law, that is the Indian Penal Code. And similarly, it has been provided that the Age-old General Clauses Act under Section 6, that provision will also come into play, and therefore all those pending cases would continue to be determined by the provisions of the Indian Penal Code. Thank you. So this act is very much relevant in the present situation. The Indian Penal Code that was drafted by the Britishers was meant primarily to serve their interest. It was adopted in the year 1860, so more than a century old law, in fact more than 150 years. It has been used in the country, and post-independence for the past 75 years, this law has governed our criminal justice system so far punishments are concerned. Now the government decided that we need to have something attuned to our Indian culture, Indian philosophy, and it is with this intention in mind that the government set up a committee with a mandate, and this mandate was fulfilled through the committee headed by the Vice Chancellor, the then Vice Chancellor, by the then Vice Chancellor, Professor Ranbir Singh of National Law University, Delhi.
Thank you so much everyone for hearing us about the new law, that is Bharatiya Nyaya Sanhita, which replaced Indian Penal Code of 1860. And I would like to thank Sir also for keeping our request and coming to our studio. And if you have any admission related query, you can just visit our USTM website. Thank you so much.